and welcome to a fresh episode of Legal Wrangle on indirect taxes. Today we start with the Supreme Court decision where the burden to prove eligibility of a benefit notification was made obligatory on part of the importer. Then we bring you 4 important decisions relating to service tax liability on an octroi agent, electronic uploading of declaration forms, utilization of SENVAT credit during suspension of facility under Rule 173G of Central Excise Rule 1944 and restriction of exemption notification upon import of similar goods. The assessee imported a web printing machine and claimed concessional rate of custom duty under the open general license as per the government's notification. The custom authorities, however, denied the benefit. Therefore, the assessee was not given the possession of that machine and the same was warehoused at the port. Let's go to Dimple for more details.
Assessee had also requested the customs to allow physical inspection of the machine, but the same went unanswered. Thereafter, the assessee filed a writ petition, as a result of which it was allowed to take possession of the machine till the final order. In its final order, the High Court held that the said notification was not applicable to the assessee as it has not been able to satisfy one particular eligibility condition relating to the output of machine.
The Apex Court held that the burden of proof was on the assessee to establish that the machine imported by it generates more than specified output as mentioned in the notification. The assessee has failed to do so. The contention of the assessee was that High Court was not competent to decide the issue in exercise of its writ jurisdiction was rejected, as the assessee itself had earlier requested the court to decide his appeal on merits. In our second case, the assessee is an octroi clearing agent. For the clearing services of octroi provided to their clients, assessee was held liable to pay service tax under the category Business Auxiliary Service. The concern here is whether mere reading of invoices and challans by the assessee for the purpose of obtaining clearance at check posts amounts to dealing with or handling documents of title. Let's have some details of the case.
When the goods arrive at the check post, assessee facilitates in payment of octroi by filling up various forms and presenting the same before the octroi authorities for determination of octroi amount. Assessee also deposits amount of octroi on behalf of its clients and obtain clearance under the Octroi Act. For this, assessee charges its client a commission on the amount of octroi assessed. Assessing authority held that the said services provided by assessee were classifiable under head Business Auxiliary Service. As a result, a show cause notice was issued and demand was confirmed. The Commissioner also rejected the appeal of assessee.
Sestat held that mere reading of the invoices and the challans by the assessee for the purpose of filing up the form and obtaining clearance at the check post does not amount to dealing with or handling the document of title. In the normal commercial parlance, the term dealing with title is possible when a person has the authority to transfer the title of such documents. In this case, the assessee does not have any authority to transfer the title.
For 6 months, Legal Wrangle has relentlessly served you vital judicial decisions in the taxation domain. But our viewers want more. Now, Legal Wrangle broadens its horizons into the corporate realm. We shall bring you cases pertaining to Companies Act, Competition Act, capital market rulings and much more. Please stay connected for our soon-to-be-announced first episode of Legal Wrangle on corporate laws.
In our third case, the key issue before the High Court was whether the department during assessment can insist upon uploading of declaration forms online in absence of any specific indication in the statute to provide the same in electronic form. The assessee company is MRF Limited, engaged in the manufacture and sale of automotive tires and other rubber products. Let's get the facts from Dimple.
Revenue, while dealing with VAT returns, proposed to reject the claim of concession or exemption and assess the turnover on high rate of duty, stating that the dealer or assessee did not file declaration forms online despite lapse of time. The assessee pleaded the authority to accept the physical forms as they were facing difficulty in uploading the declaration forms due to technical snag. The plea was however rejected and proposed assessment was passed.
The Madras High Court held that when there is neither specific indication in the Central Sales Tax Act or Puducherry VAT rules to provide the declaration forms online, nor any facility for such purpose, the dealer or the assessee cannot be insisted upon to comply with such direction of department. The High Court further held that the department has exceeded its jurisdiction in imposing a condition not provided by law. In our fourth case, the key issue before the Supreme Court was whether CENVAT credit can be utilized by an assessee for paying excise duty on consignment basis in case facility for payment of duty fortnightly under Rule 173G is suspended during concerned period. The assessee is Jaiswal Nekul Limited, engaged in manufacturing of pig iron. Let's hear the case details.
The revenue, noticing that the assessee had utilized credit from its CENVAT account for payment of duty on consignment basis, charged interest for the reason that since the facility to pay excise duty fortnightly was withdrawn, it was not open to the assessee to make use of CENVAT account during this period. As per the revenue, the implication of the aforesaid withdrawal of facility was to pay excise duty for each consignment by cash only.
The Supreme Court held that mode of payment of duty through CENVAT credit is as good as making payment through account current. The Apex Court observed that even during suspension period of the facility for payment of excise duty on fortnightly basis, the only obligation for the assessee is to pay the duty on each clearance and not on deferred basis. However, it can be either through account current or CENVAT credit. In our last case, the key issue before the Supreme Court was whether importers in the same category can be discriminated in respect of benefit of concessional right merely because the duty arrived by one importer was lesser. The assessee is N.S. Ratnam Sons, engaged in the business of shipbreaking and selling it as scrap. Let's have the case details from Dimple.
The assessee had cleared scrap without payment of any excise duty, assuming it to be entirely exempted as per the exemption notification. Accordingly, the revenue issued a show cause demanding payment of excise duty on the ground that by the concerned notification, entire exemption was granted only to those assessees who had paid customs duty at the rate of Rs 1400 per LDT.
The Supreme Court observed that once the importers have paid the duty as leviable under Customs Tariff Act upon their choice of method permissible under the said Act, merely because with the adoption of one particular method, the duty that becomes payable is lesser would not be a rational basis to conclude that two importers belong to different categories having no right to seek exemption. Well, this brings us to the end of this episode of Legal Wrangle on Indirect Tax. You may write to us your comments, criticism and counsel at editor@tioltube.com. Please do subscribe to TIOL Tube to remain updated. It's free and we'll keep you updated on our new posts. Have a good day.